Well, hello there. How is everyone? I hope you are all well. You fantastic, fantastic people, you. And you are looking absolutely amazing, may I add, on this wonderful Tuesday morning as we head closer and closer to Christmas. I'm going to be doing a live, I think, on the 23rd, where we're just going to have a bit of a chilled one, do you know what I mean? Just have a chat. It's more of a Christmas live. Have a bit of a drink together and, you know, do some stuff. So keep an eye peeled for that. And I'm live later today as well. Going back to the live that was scheduled before our power cut. But anyway, I'm going to get on with it because this morning we're talking about the other Idaho 4 2.0 case, the Majorjon Kaylor case. This was the young man who very tragically felt the need to completely eradicate an entire family after law enforcement had failed to listen and action on concerns that he had that his young daughters were in danger. I don't know if all of you have heard of it. If you haven't heard of this case at all, I have done other videos on it, kind of outlaying exactly what happened, and I can talk a bit more about this in the live later today. But there has been movement, and in order to explain more, we need to just go back to the first court document. So let's just touch on how this started. So he was obviously charged with murder in the first degree 4 times because there was 4 victims. There's the 2 parents and the two kids. I say kids, young adults. One of them was, I think, the one who he had a major complaint with, I think was 18. Some people say that's a kid, and do you know what? I think nowadays the mentality of our youth, I think you have to be about 25 to be sort of half compos mentis. Some people anyway. Some people mature a lot sooner. But yeah, so he was charged with 4 counts of murder in the first degree, and as we see in a lot of cases, burglary as well, which is normally attached to these cases to offer a degree of intent. This person entered someone's home in order to commit a crime. It's part of the proof of premeditation. We saw it in the other Idaho 4 case as well, where Brian Koberger was also charged with burglary. So that's where it all started. So he was charged with that, and now we have this. So this is the latest document where there's been an order to amend information. So after reading the stipulation, which we're going to go over that document in a moment, but it says there, now therefore it is hereby ordered that the state file an amended information in the above entitled matter charging a violation of IC 184001 and a degree of numbers there. But basically it's to change the charges from murder in the first degree to murder in the second degree, a felony count 1, 2, 3, and 4. And the burglary stays the same as the count 5. So that is the district judge, and we have this. So what spurned this on? How is this now being considered, you know, from murder in the first degree to murder in the second degree, when from the outside you would just kind of think, well, this guy's entered into this house and he has murdered an entire family. This is where the law gets very, very complex, because there is a difference between murder in the first degree and murder in the second degree. And it's very important to understand whether the state has proven that the crime that they are charging sort of, it goes, how can I say, that it is indeed fitting all the criteria for murder in the first degree. So let's get rid of this one. And we'll go back to here. And this is it. So there was a motion to dismiss. So matter before the court, defendant Majorjon Kaylor moves to dismiss counts 1 and 2 of the information. The state opposes defendant's motion. By stipulation of the parties, certain exhibits were admitted and the matter was submitted to the court for a decision without a hearing. For the reasons stated below, defendant's motion is denied. So the defendant is charged in counts 1 and 2 with violations of these numbers: murder in the first degree, felonies allegedly committed as follows. So count 1, that the defendant, Majorjon Kaylor, on or about the 18th day of June 2023 in the county of Shoshone, state of Idaho, did willfully, deliberately, and with malice aforethought unlawfully kill the person of Kenna L. Guadapi, a human being, to wit, by shooting her, which resulted in her death, and which was premeditated and or to execute vengeance. Now, these both are... This is where it gets complicated, because this is the issue with premeditation and to execute vengeance. And it's important to understand that these two, what they're talking about, Kenna and Kenneth, are the parents. And what the main complaint wasn't with them. The main complaint here was that one of the sons, the eldest son, had basically been flashing his meat and two veg at the young girls, Majorjon's daughters, and playing with the old beans. And he didn't obviously like it. He'd gone to law enforcement and said, look, I'm not happy with what's going on here. I need someone to come out and sort this out. And he'd reported this a couple of times. They did fuck all about it, to the point where something's happened where he's been sort of playing with his meat and veg again in front of the kid. And the Majorjon's blown his nut, and he's gone absolutely bananas, grabbed a handgun, walked into the house and just executed them all. But, it's this premeditation to execute vengeance with respect of these, it's not really how this played out. I can certainly see that that's not what happened here. The defendant argues that counts 1 and 2 must be dismissed because the state has not disclosed sufficient evidence to prove those offences were committed in either a premeditated fashion or to execute vengeance. Defendant cites no authority on point. Instead, he bases his motion on general concepts of the ends of justice, effective administration of the court's business, and delay found in Idaho Criminal Rule 48, which states, dismissal on motion and notice. The court on notice to all parties may dismiss a criminal action on its own motion or on motion of any party on either of the following grounds: for unnecessary delay in presenting the charge to the grand jury, or if an information is not filed within the time period prescribed by Rule 7F, or for unnecessary delay in bringing the defendant to trial, or for any other reason if the court concludes that dismissal will serve the ends of justice and the effective administration of the court's business. Order of dismissal. When a court dismisses a criminal action, the order of dismissal must state the court's reason for dismissal. Effective dismissal. An order for dismissal is a bar to any other prosecution for the same offence if it is a misdemeanor, but it is not a bar if the offence is a felony. Rule 48 does not provide for pre-trial dismissal based on insufficient evidence. And then they've got a case here that they've used as a reference. Now they're talking about a waiver here. So, moreover, defendants signed and filed a written waiver of preliminary hearing, stated, I understand that I have the right to a preliminary hearing on each charge. I understand that at preliminary hearing, the state must present evidence which shows that a crime has been committed and there is probable cause, and I believe I committed the crime. I understand these rights, and by signing below, I waive my right to a preliminary hearing. Waiver of preliminary hearing at 1 to 2, file, blah, blah, blah. By executing these documents, defendant demonstrated he understood his right to a preliminary hearing on all charges, and further waived his right to require the state to prove before trial that there was sufficient evidence that he committed the crimes alleged in counts 1 and 2 as well as other counts. So what they're basically saying here is, and this is interesting when we cross this over into the other Idaho 4 case, and the importance of a preliminary hearing and the difference between a preliminary hearing and a grand jury indictment. So what they're basically saying is here, if you felt that the charges weren't right and you wanted to argue them, then why put in a waiver to waive your rights for a preliminary hearing? Because it's at that stage when you would have had your say and say, look, I ain't happy with this, it's in what it is, and provide evidence to support. But you didn't. You waived that right. And now we've got down the track and you're now wanting to backpedal, and we don't have to. A waiver of preliminary hearing by a person accused of a crime operates as an admission of the existence of probable cause, justifying that the accused is held for trial. State versus Hendricks, blah, blah, blah. In cases where a defendant accused of a public offence triable in the district court waives preliminary hearing, no depositions to support the charge in the district court are required. The accused in such circumstances is held to answer for the crime charged in the criminal complaint filed with the committing magistrate. If an accused desires testimony taken before the committing magistrate, he could, by demanding, secure a preliminary hearing and ascertain the facts on which the charge was based. Respondent having waived such a hearing, he is not now in a position to complain. So basically, it's exactly what I said. If you wanted to moan, fucking say, do you know what I mean? You had your chance, you've waived it, fuck off. But how was that? Do you know what I mean? That's life. Do you know what I mean? This is court anyway. So anyway, let's skip down to this. Premeditation. Even if defendant had not admitted that the evidence was sufficient to support the charges, and even if Rule 48 permitted defendant to contest the sufficiency of the evidence before trial, the state has submitted sufficient evidence within the stipulated exhibit showing premeditation. Defendant has not asserted any particular standard of proof. If defendant had not waived preliminary hearing, the applicable standard of proof would have been probable cause. A defendant once held to answer to a criminal charge under this chapter may challenge the sufficiency of evidence adduced at the preliminary examination by a motion to dismiss the commitment signed by the magistrate or the information filed by the prosecuting attorney. Such motion to dismiss shall be heard by a district judge. If the district judge finds that the magistrate has held the defendant to answer without reasonable or probable cause to believe that the defendant had committed the crime for which he was held to answer, or finds that no public offence has been committed, he shall dismiss the complaint, commitment, or information and order the defendant discharged. So again, we refer back to the other Idaho 4 case, and we now kind of see what perhaps it's not perhaps, it's absolutely fucking lootly why they filed for a grand jury indictment round the back of Brian Kohberger. They knew, and I still stand by this statement, that the Idaho 4 case was a weak case, and they knew that there was a possibility that Brian Kohberger was going to walk. Now, is it because they feel that he's absolutely guilty? Maybe someone saw him. Maybe there is, but they can't fucking prove it. This is what I spoke in the video yesterday about. It's still a case of when decent people do shady shit and it goes fucking wrong. But anyway, in addition, direct evidence of a deliberate and premeditated purpose to kill is not required. Such a purpose may be inferred from the facts and circumstance of the killing. And then they go through there. Premeditation means to consider beforehand whether to kill or not to kill, and then to decide to kill. There does not have to be any appreciable period of time which the decision to kill was considered, as long as it was reflected upon before the decision was made. A mere unconsidered and rash impulse, even though it includes the intent to kill, is not premeditation. And we have spoken about this as a community before. When we talk about premeditation, how long is premeditation a consideration in terms of time? How long do you have to have? If you snap and kill, then there's no premeditation. But if you hesitate for a second and then you kill, is there premeditation there? If you have a period of time where you can consider your actions, there is premeditation. It says in Stale and Bar, Idaho, blah, blah, blah. The Idaho Court of Appeals cited this instruction and held that Barr's actions were evidence of premeditation, including but not limited to his taking a gun from the nightstand of his mother's boyfriend prior to meeting his ex-girlfriend. So again, this is trying to point out the fact that he entered the property with a weapon is enough to prove premeditation of the crime. And that's what they're trying to argue here, in my opinion. So it forwards hair look. So on this June 18th, 2023, the defendant came home from work, ultimately took a large caliber handgun with sufficient ammunition to fire multiple rounds. Defendant did this before a 5-minute argument with Kenneth and Kenna Guadapi. Defendant appears to have had a significant concern regarding the actions of Devon Smith, and to the extent that he perceived that Kenna and Kenneth were not taking acts of Smith masturbating in front of the defendant's children seriously. A reasonable inference is that defendant appeared to be looking for vengeance or reckoning. Now, he wasn't looking for vengeance and reckoning. He was looking for them to listen to his concerns and do something about it, and show him that they were going to do something about it. And it sounds like this family just, and again, I could be wrong. It's a very tragic situation. Defendant apparently perceived a need to protect his children because he believed the police had not yet done so. Defendant told his wife, Kaylee Kaylor, to tell his children that he protected them. While speaking with Kellogg police officer William Eddy on June 12, 2023, defendant said the only reason nothing happened that evening was because he had just had shoulder surgery, apparently to give him time for reflection and healing, but that he would handle it and somebody's going to be hurt if something happens again. There were multiple gunshot wounds to the victims. There were gunshot wounds to Kenna's right hand, torso and temple, the latter of which was likely at very close range, shown by the muzzle imprint and likely very close to the ground. There were gunshots to Kenneth's torso and head. Defendant called 911 saying, "I just went downstairs and executed a fucking paedophile and his family. Shot 4 people, are all dead." Defendant's use of the word execute is consistent with premeditation. So this here is exactly why you guys have said in the US we're sort of taught not to say a fucking word, get yourself legal representation. Because even that, the use of that one word, they are saying that because he used that word, there was premeditation there. And conclusion, because defendant waived his right to a preliminary hearing, admitted there was sufficient evidence to support the charges, and because there is no valid basis in law for defendant's motion, and because there is sufficient evidence to believe that the killings alleged in counts 1 and 2 were premeditated, defendant's motion is denied. It is therefore ordered defendant's motion to dismiss is denied. So, like I say, motion to dismiss is denied. But it would appear that there's a possibility that they have been or looking to reduce them down to murder in the second degree rather than murder in the first degree. But let me know what you think down below. Have you been following this case? What do you think? What would you do if you was in his position? Again, I've always said this is a difficult one. When it comes to your children, some people will do absolutely anything in their power to protect their children. If they have gone to everybody else and nobody else is doing anything, what are people supposed to do? Are they just supposed to wait until their children are hurt or worse, or their entire lives destroyed before doing anything? Again, a very, very tragic case, but it's moving. There's a trial set for early part of next year already because of the waiver of a preliminary hearing. So this is going to start moving quite rapidly come 2024, and I will be following it. If they do televise it, I will, of course, be doing the exact same. This is a case we've stuck from the beginning. Anyway, let me know down below what you think, and I'll catch you all this evening.